Good afternoon, everyone. This is the House Judiciary Non-Civil Committee. We've got two bills on the full committee agenda that were considered yesterday in public hearing. The first one we'll take up is House Bill 863. This bill addresses the issue of animal cruelty. And even though this is the first substitute that we've had actually this is not the first substitute, it's the second substitute in front of the full committee, but it's not but it's gone through many changes from the as introduced version of the bill. What this bill does is add in provisions. It strengthens both the misdemeanor and felony provisions as it relates to cruelty to animals. The main crux of the bill really begins on line 31, although the definitions are important, and we've reduced the definitions and simply simplified the definitions on adequate care. We had much more extensive and expansive definitions beforehand. That caused some real problems with otherwise legal conduct, including activities of our sportsman community, and it got so specific that otherwise it created the potential so that otherwise lawful conduct and traditional conduct, for lack of a better term, would possibly get caught up in a net that was not meant for, frankly. So what we've done is we've gone ahead and made some changes that you can see on line 31. The offense of cruelty to animals occurs causing physical pain, suffering, or death to an animal by any unjustifiable act or omission, or having intentionally exercised care and control of an animal, meaning this is my animal, I'm taking this animal on, etc., failing to provide adequate care to such animal. And the adequate care definition that you can see begins on line 13. And I think the main thing I want to stress with regard to adequacy, and this really came from the testimony of animal control officers and the prosecutors, line prosecutors that we've worked with on the drafts and redrafts and more redrafts on this bill, and their statements yesterday, is that what they really see more than anything else are neglect cases and starvation cases, and this will go ahead and address that directly. But what we did not want to do is get into too complex a definition of adequate care, because adequate care is in large part an eye of the beholder determination, where it may be in West Georgia, maybe a different definition, let's say, in Swainsboro or in Marietta. Or I gave the example yesterday about someone in my Rotary Club who ran the Iditarod race, and in Alaska, and adequate care for those dogs up in making the run to Nome is different than what it is in the Vinings area of Cobb County or in West Georgia or wherever. And those animals are bred for specific purposes. They have different instincts, and certainly a jury, I think, there will go ahead and have a different definition of adequacy than they would here, and that's the way it ought to be. I think it almost comes under what you could probably fit in the words community standard, under that, and that's appropriate. That's appropriate because I think in a community, we heard from the DA, Mr. Altman from Swainsboro yesterday, who was very open about how, yes, we have a sportsman's culture, there and all over the state, certainly outside, the metro area mostly, but not uniformly. And the definition of adequacy there is different than it is here, and I think that's appropriate. I really do. And the intent of this bill, and I believe we've gotten, more importantly, the wording of this bill has gotten to the point where we're not gathering up otherwise legal conduct that we certainly do not want to criminalize. So that's the misdemeanor portion. When we get down into malicious conduct, really beginning on line 57 of the sub, and I'm sorry, LC 295944S. LC 295944S. Then you're getting into aggravated cruelty of animals, maliciously causing the death, depriving it of a member of its body, rendering an animal's body useless, seriously disfiguring, torture, poison, and then And then a really important provision on line 67, having care and control of an animal maliciously fails to provide adequate care to such animal to the extent that the death of the animal results or a member of its body is rendered useless, body member seriously disfigured, going back to the language you saw earlier. And that's really what we're talking about here, is that kind of mistreatment to the point of I don't know how to I really don't know how to put that into words. And but that's really what the line prosecutors and the animal control people are seeing more and more, and that's really what this is in part addressing, along with poisoning, torture. I think we all saw the story in some way, shape, or form a few days ago of the individual who put a dog in a box and threw him out the window. That's the kind of person that we're going after here and strengthening the penalty provisions while we do it. But again, not wanting to get into otherwise legal conduct, and we have provisions in line 88, which is existing law, and I think it's important that people understand we have existing law that nothing in the code section, whether in existing law or new law, goes ahead and should be construed as prohibiting conduct which is otherwise permitted, agricultural, animal husbandry, and you see the laundry list beginning on line 90. That is existing law, and again, otherwise legal conduct is something that we do not want to get caught up in. Then we have the provisions beginning in on line 102 regarding the justification or lack of justification in putting an animal down. And I think those are pretty straightforward and pretty commonsensical. So with that, what I thought I would do is answer whatever questions I can. I'll invite Mr. Spehaus if he wants to. This bill was written in collaboration with the Prosecuting Attorneys Council, and appreciate all of their help now and in the future on making sure we get it right and we continue to strike that balance. Mr. Hightower. Oh, I'm sorry, Mr. Coomer.
Thank you, Mr. Chairman. After our last meeting, you told me you really appreciated the questions I had and how helpful they were. So
sure. Hopefully
they'll be helpful on this bill as well. I have a couple of concerns. I guess the sort of broader concerns that are not specific to the bill but may arise from the bill. What about circumstances involving research on animals and circumstances involving training of animals that may involve an animal being struck with a device that is commonly used for the training of such an animal, or even, for example, what about a horsewhip or a riding crop? Would those kinds of activities? How can we make sure that those kind of what I would say accepted activities
right.
would not get caught up in this language?
Right, and I appreciate the question. Understanding that what I do is I look at the existing provisions that I referenced earlier in line 88. Nothing in this particular code section. Again, this is existing law prohibiting conduct which is permitted, and I see scientific comma research. I don't know if that needs to be cleaned up or not. But
I'm sorry, where were you?
Line 91 of the sub. And it's a laundry list of agricultural, animal husbandry, butchering, food processing, marketing, scientific research, medical, zoological. It's a hunting, trapping, fishing, wildlife management, pest control. Nothing. I would see that potentially as all coming under. And as a practical matter, again, you've got one thing that I want to make sure is clear. I go back to, so having looked at that provision and also looking at line 34, causes physical pain, suffering, or death to an animal by any unjustifiable act or omission. We're talking about otherwise legal conduct. So if somebody goes ahead and they're doing the field trials, which I have a vague understanding of, but I certainly understand dog training. I've had lots of dogs trained by professionals, and I'm aware of the techniques that they use, and I'm comfortable with that. So I don't see otherwise legal conduct like that, which I've experienced myself, and that's part of the dog training process. I don't see that as an unjustifiable act or omission. I think it's otherwise legal conduct, and so I don't think it applies.
Would you be willing to allow us to amend that paragraph that starts on line 88 to include the word training in that list of activities?
My initial reaction to that is that I don't think it would be problematic because, again, it's otherwise legal conduct, let me, out of a sense of due diligence, ask Mr. Spehaus if he thinks it would endanger the intent of the bill. My sense is that it would not, given the laundry list that's already there. And again, we're talking about otherwise shall not be construed as prohibiting conduct which is otherwise permitted. That's otherwise permitted conduct. So, but I reserve the right to be wrong, Mr. Spehaus.
I think you hit on the point I would have made, is that you got to keep in mind that the statute currently requires an intent element, even on the misdemeanor side of it. Understand that the current law says that you commit an offense by creating unjustifiable physical pain or suffering by an act. I mean, that's the extent of it. And the behavior you're discussing is not getting prosecuted under the current statute. I mean, it's not a problem that has occurred prior to that. So this breaking it out, and quite frankly, just adding having intentionally exercised care and control, failed to provide adequate care to such animal, is the only thing that's being added of substance to the misdemeanor portion of it. And the felony portion requires malice, which is a much higher level of intent. So do I believe putting the word training in this laundry list of things would hinder the bill or not? I don't see where it's that big a deal one way or the other, because I submit to you that if you were violating the code section that we're proposing now, or even the current law, and you did that while in the business of butchering or medical or zoological or any of these other laundry list of things, that you could be prosecuted now. This laundry list doesn't prevent these actors from being prosecuted. It's just, as a policy statement says, lawful conduct surrounding that is fine. So I don't think the long answer to that, or short answer is no, I don't think it hurts anything.
Okay. And I'm just thinking, since we're going to try to remove that comma, be an easy thing to do. The other thing I wanted to ask, let's see, well, two specific issues. One is on lines 27, 28, wanton and willful doing of an act with awareness of a plain and strong likelihood that a particular harm may result. Can we talk about what particular harm means, or what harm means in this context, and is it already defined somewhere else? Is there a floor or a ceiling?
If I could, Mr. Chairman, I'll speak to that language. That language is pulled out of the current 2013 pattern jury charge for aggravated battery. The concept of malice is pretty consistent throughout our code. The first time I saw that language, I said the same thing. I said, what exactly does that mean? The plain truth is that's what gets charged to a jury. It comes straight out of some appellate court cases, Georgia Supreme Court cases. It is word for word how you define malice. And that's
in the context of injuring a person, I mean, it's easier because you can have a person testify, that hurt me and I was bruised for a week, or I broke a bone. And I know breaking bone, you won't need a testimony for that. But how is that? Isn't it a little more complicated when you're talking about an animal?
Not an aggravated battery, because aggravated battery is not just battery, but it's the same additional elements as required here, which is the death. Let me get over to that part. That's where that language comes from, is to the extent of looking at line 68. Such animal, to the extent that the death of such animal results, a member of its body is rendered useless, or its body or member thereof is seriously disfigured. That's an objective standard. That's got to be present before that malice is an issue.
It makes sense to me now. Thank you for explaining that. And the last part is on the last question I have now is on 63, line 63, 64. And this is under the section that describes aggravated cruelty to animals, and it says that a person commits aggravated cruelty to animal when, and in line 3, the person maliciously tortures an animal by the infliction of or subjection to severe or prolonged physical pain. And it's kind of the same type question I had about harm, but do we have any guiding language anywhere that tells us what would qualify as severe? Prolonged pain, I understand what that is, but severe pain in this context?
Quite frankly, in my opinion, to prove that case, in an animal case, it's going to be very much the problem you indicated. It's one thing when you do it to a child or a person and they can testify to it. That's not the case in an animal situation. But that doesn't mean that you can't use expert testimony and other evidence to prove that. So there's other ways to prove that. I'll be honest with you, that's a pretty high burden as written. But I mean, those words get the common meaning associated with them, and you know that torture statute is that's going to be a pretty high burden to prove. But I also think it puts the whole world on notice of the behavior that you're trying to forbid.
Would it defeat the purpose in this section if we remove the word "or" on line 63 and said that it is the infliction of or subjection to severe prolonged physical pain?
By the infliction of subjection to. I think infliction and subjection are two different alternative theories by which you would.
That's the wrong "or." I'm talking about the "or" at the end of the sentence between severe and prolonged.
And make it an "and."
Yes, or just leave it.
I don't think
no
you
word.
can leave it subject to severe.
You can put a comma. Severe
I got
prolonged.
you. Severe. I think it gives you two right now as written. There's two theories under which you could commit that. Once you do that, you've combined those into one. And I think you've made it even more difficult than what I had said that I believe it is now.
Severe doesn't have to be prolonged.
Right. Severe could be substantially worse than the prolonged would be.
Okay. Thank you very much.
Thank you. I appreciate the questions. I'm trying to get this bill as perfected as it possibly can, and I appreciate the feedback. Mr. Hightower.
Mr. Chairman, Representative Coomer and I did not talk about this prior. Those were he just had a lot of the exact same concerns.
Well, great minds think alike.
You and
I
I
know.
talked about earlier. Mr. Spayhouse, you said just a minute ago that the term unjustifiable act was in current law. Where's that at in current law?
We're actually, let me get back to that.
Because you said unjustifiable act is in current law and it's not being prosecuted now.
Right.
But I
Line
didn't see it.
32, see where we're striking it to move it? Unjustifiable physical pain. So cause death or unjustifiable physical pain. That's being struck. That is the current law. And it's being redirected into 34 to 35.
Okay. And then one other. Quickly, you on line 27, when Representative Coomer was talking about the wanton and willful, there you had referenced him to line 68 and said that those things would have to be present to show the malice part. But line 68, the way that I'm reading this, doesn't apply to the malice portion. Malice is under 23, which goes to, it seems as though it goes more directly to the misdemeanor, is it not? And then the maliciously, that's on 57, that goes more towards the felony.
Yeah, if you look on 67.
Just step me through, I apologize.
Yeah, no, it's fine. The malice definition is defined above, but only used in the felony provisions. Now, what messes you up is the fact that the word malice is the first word in each one of the provisions until you get down to 67 and paragraph 5. But malice is still an element there. Having care and control of an animal maliciously fails to provide the adequate care. So malice becomes an element in each of the felony provisions. So what I meant to say earlier, or what I thought I believed I said, was that you've got to have malice as an element, and you've also got to have, to get to 5, that extent to which the death of such animal results, the member of the body is rendered useless, or the member is seriously disfigured. So that's the only place that you're getting to under a concept of failure to provide adequate care. The misdemeanor version above, malice is not an element, but what it is the original language that's in the code now causes physical pain, back to 34, causes physical pain, suffering, or death to an animal by an unjustifiable act or omission. That's the same concept that's in the law now. What's being added, it's at 36 and 37, is having intentionally exercised care and control. So nobody can drop an animal off and impose liability on you. You have to have assumed some liability or assumed some responsibility for an animal, and then you failed to provide the adequate care to such animal. So that's the only two ways a misdemeanor will be prosecuted: the current version, or you take care and control of an animal and then fail to provide adequate care.
Most of my concern was taken up when you agreed to the training portion, which is what you and I spoke about earlier, Mr. Chairman. So if we're adding that, I think that's going to go a long way to alleviate my concerns. And just so you know, my concern was I train a lot of dogs. I help friends train their dogs. We've grown up training bird dogs and retrievers my whole life, and there are certain techniques that you knowingly and willfully inflict pain. And I know some people, they gasp when they hear someone say that, but I relate it back to the way that I was brought up. My dad inflicted pain on us when we did things wrong, and it was a definite deterrent. Right. And it hopefully yielded good results in his mind.
The jury's out on that right now.
But if it was okay to do it to me, I mean, it's done appropriately, it can get you where you want to be. You said, I mean, it's proven to that the way we discipline our kids. So I don't want to not be able to do that to an animal that I'm trying to get to act appropriately as well.
And I mean, in all seriousness, I mean that point is well taken. And again, like my retrievers, you know, they went to puppy university for a couple weeks, and I don't have any delusion. They said you can't come visit, and there's a reason for that. Yeah. You know, and we knew full well why, and that's okay. Yeah. You know, that is part of the training process, but otherwise legal conduct, and that's really where the rubber hits the road, and that's, you know.
And I do like the fact that we're going to be able to hopefully add the word training, just as it makes me feel better a little bit. But the thing that concerns me, and the reason I'm glad we're adding that particularly, is because of the word unjustifiable act. Especially, you know full well that as prosecutors, and I'm one for a couple of municipalities, we get great discretion on what we deem to prosecute. And unjustifiable may change every election from what prosecutor's there to the next, because it may not, what may be unjustifiable to one may not be as unjustifiable to the next elected person. So as much as we can give guidance like this training to give someone something to fall back on, I think it's helpful.
I think given the reason I'm comfortable, just to make sure it's clear, is that given the fact that we have that extensive list beginning on line 88, I mean, that to me communicates the intent of the legislature way back when, that there was going to be recognition of this otherwise conduct otherwise permitted under the laws of this state. And to me, that folds in nicely, but it's not a get out of doing bad,
right,
you know, card. And that's the difference. And to hear the prosecuting attorney's counsel confirm that is comforting. So, Mr. Coomer.
Thank you. First of all, let me say, sorry your dad was using that shock collar on you. I know people that can help you through that pain, though. But my question is, I have a pretty rural district, and I know many stories in the last few years of people who had, in particular, horses, and when the economy fell apart and people started figuring out how to make their mortgage payments, they quit taking care of their horses, and of course, the easy response to those folks is, well, you should take your horse somewhere and have it taken. You should leave it somewhere to be taken care of. But it's not so easy to take a large animal and just drop it off somewhere and ask somebody else to take care of it. So my question is, is there anything in this bill or that you're aware of, maybe in the law, that allows that person any protection under the law? Are they guilty under this code section of cruelty to animals?
I don't know that they're guilty. I mean, what the policy behind this, and I can defer to the chairman about it, but my understanding of the policy behind this is, if you have made the conscious decision to exercise control and care of an animal, this body is imposing on you a certain level of responsibility, which is being defined as provide adequate care. I think there's certainly some mitigation to the fact that you're having a hard time finding somebody else that could take care of that animal, and I think that's a factor that could be taken into consideration about what to do in that case. But I mean, this is a clear policy statement that, you know, if you've made a decision in this state to take control and care of an animal, then you need to at least provide the minimum, which is, you know, water and food, that kind of thing.
Thank you.
And I think from a factual standpoint, and again, that situation, and the gentleman knows this better than I do. That's going to be a very fact-specific situation. My sense of it is, in the real world, it's going to come down to what that individual horse owner, what steps they attempted to take and when. I mean, there is a good faith element that goes into that, and it goes into this type of situation. That's not news to anyone. I think it's where you're talking about this, you know, and I would defer to the line prosecutors who look at these on a daily basis. It's going to come down to what action they attempted to take and when to, you know, in attempted compliance. Sometimes, you know, there's going to be a non-compliance situation in life, but the question is, what did you try to do? What was the good faith effort? What was the attempt? And then candidly, you're getting down to the discretion of Mr. Spahas's, you know, members throughout the state. To me, and the gentleman may disagree, but I think it's pretty commonsensical. It's going to come down to what did they try to do and when? What affirmative good faith steps did they take to try to alleviate the situation, knowing full well that there's no guarantee that they could have. No guarantee. But I have got to think that that's got to be into the contemplation in the discretion of the prosecutor. It has to be.
Last question.
Sure.
Does this bill add any authority to the Department of Agriculture to enforce? Do they have the authority to enforce this provision now, or would they become an enforcement agency under this bill?
I can't speak to under this bill. There's no added authority.
Okay.
I know that for a fact. Nothing in this bill steps on existing Department of Agriculture regulations. I know that as well, and have been educated accordingly. As far as their enforcement authority now, I honestly couldn't tell you, Mr. Spahas.
No, I mean, this provision, this law is generally in the enforcement arms of animal control counties, local law enforcement. That's what this doesn't expand agriculture's authority at all, like the chairman said. I'm not aware of them having any law enforcement. Maybe they do. I don't know. I've never prosecuted a case that they brought, but no, this just cleans up the criminal provisions.
And just by way of information, yesterday at the hearing, I asked them the question: are there any concerns? Not necessarily in that area. Are there any concerns in the language of the substitute? And they said no. I was very concerned about having a conflict between what we pass out of here and then what exists in regulation. That's a disaster from an enforcement standpoint. But that is not the case, and Department of Agriculture testified as such yesterday. I don't see any other questions. I appreciate the questions because this bill needs to be as good as we can get it. I don't see any further questions. What's the pleasure of the committee? Mr. Coomer moved due pass of House Bill 863 LC 29 5944S. Are there any amendments? Mr. Coomer.
Yes, Mr. Chairman. I move to amend line 91 by striking the comma between the words scientific and research, and by adding, let's say, after the word research, the word training.
Comma, medical, zoological, etc.
Yes, sir. So it'd be a comma after research, training, comma, and then carrying on.
Okay. Is there any objection to the amendment? Is there any objection to the amendment? Hearing none, it's agreed to. Are there any further amendments, Mr. Pack? Oh, I'm sorry. Are there any other amendments? Seeing none, all in favor of the gentleman's motion of due pass by substitute. Let me back up 1 second. To the extent that, I don't know, this may be sort of a macro amendment. My sense is that in that paragraph, I don't know how long it's been there may be some grammatical missteps in there and commas. In looking at it, it seemed like competitive. Competitive what? You know, you see it on line 91. Without getting into the actual wording of it, if there is just punctuation that needs to be cleaned up, should we, counsel, do you want us to give you authorization to do that, or you just want to leave it?
Yeah, well, the small changes you've made here, I don't have any questions about.
Right.
Done through editing, so I don't feel like, unless you guys really want to just
No.
change the language, I don't think you need
No, I don't want to make it more complicated. So, all right, I'll take it back. All in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mr. Spehouse. And thank you, members of the committee. Let's call House Bill 965. Mrs. Cooper, if you can do it from there, you can do it from there, whatever you're comfortable with. Absolutely. All right, we'll begin the full committee's consideration of House Bill 965. Representative Cooper, welcome.
Thank you.
The floor is yours.
Thank you, Mr. Chairman. If I might just revert back to my former job as a college professor, I'd like to recognize 3 young people that are here.
Sure.
The first one, the reason that I'm bringing this bill is because of a young man that had several friends die. Justin is now a freshman in law school at Georgia State and was my intern and brought it to me. And Justin's in the audience. Justin, stand up. And if young people don't think 1 or 2 young people can make a difference in the world today, I passed a couple of young people in the hall and they stopped me and said, "Are you Representative Cooper?" And I did. And it's S.M.E. Bancroft and Jeremy Sharp. You two stand up right here. Thank you. From North Georgia, both of you? And Georgia State. And they had done a peer review update of drug over abuse, the epidemic that we're having in Georgia. And one of the things we talked about yesterday was that how would if this bill should pass, how would we get this out to young people about the changes in the law? And they are committed to doing that and have a group of friends at different colleges all over Georgia that they would contact. So I think we're looking at 3 young people that are definitely going to make a difference in our world as they grow older, and they're already becoming involved in the process. So thank you for letting me do that. The substitute to House Bill 965 is an amnesty bill. As we have passed laws to tighten up on opiate prescription drug overdoses, and we've done away with tried to do away with all our pill mills. The drug cartels, have found it very advantageous to increase the flow of heroin into the state of Georgia, and it is much more reasonable in price. Someone can get a high on $10, and we are seeing a dramatic increase of drug overdoses in young people between 18 and 29. And with that dramatic increase in drug overdoses, what so often is happening, we're seeing an increase in number of deaths, and many of those deaths could have been avoided. But other young people that are doing drugs with the person that dies often abandon that person for fear that they are going to be prosecuted if they stay with them, and if they call 911 and stay with them until help comes. And so this bill is basically sort of a pattern on the one we passed several years ago, where we said we had an epidemic in this state of mothers putting babies in trash cans, having them drowned in the toilets, and abandoning them in various other places and where the babies died. And we said, as a legislative body, if you will take your baby to a safe harbor and leave them, we will not prosecute you for abandonment. So what this bill does, it says that if a young person is doing drugs and they become into a state of acute medical emergency where they are in danger, basically of dying, that if they call 911 or one of their friends call 911 who happen to be doing drugs also, that neither will be persecuted if they stay with them until help comes. And that is the essence of the bill. There are 14 other states that have these, I believe 14 other states that have these law, including South Carolina, Justin, South Carolina? Florida and North Carolina, and there are almost the same number of other states that are contemplating the law. So with that, I'll be glad to answer any questions, and if there are legal questions, I really appreciate the fact that Mr. Spehouse has worked with me on this bill and is here to answer your legal questions also if you have them.
Ms. Kendrick. I'm sorry, Ms. Strickland.
Thank you, Representative Cooper, for bringing this bill. I think it's a good bill. I just have one logistical question. Maybe it is more for Chuck. When would you raise this defense? Would it be a jury charge in a case? Would it be via like a pretrial motion? How would this be presented as a defense?
I mean, it's a ban of prosecution. I mean, it would be a plea in bar.
Okay.
I mean, it's quite frankly, I mean, it would just go into be taken into consideration at the time of charging. But I guess if a prosecutor were to charge this, and you wanted to raise it as a defense, you would raise it by plea and bar.
Okay.
And I will say that one of the things that Mr. Stahouse went through the bill was to make sure that the bill couldn't turn around by drug dealers and used as a defense for them, and added the language to make sure that we were not going to give the bad guys a pass, that we were really looking at someone who makes the mistake of maybe taking makes the mistake, first of all, of doing drugs, but then gets a really pure form of heroin and overdoses. And I think there were parents here yesterday. I'm glad all of you did not have to see the suffering of the mother whose child had seizures for an hour and a half. They were in a shack behind a house, and there was adults in that house, and they didn't call. And when the young man died, and he was an Eagle Scout, and this was his first time, and they put him in the back of the car, drove him around, and dumped him out in his mother's front yard, and she found him when she came home from church. So the main thing is in what the parents said. If you have a live child, they've got another chance. You've got a chance to see them correct their lives. And one mother even testified that her son died, but he had done drugs with this other group of young people, and they had kept up with she had kept up with these young people, and they have all kicked the habits. They are all married and living productive lives. Her son didn't have that chance because he was abandoned.
And if I could, to finish, this bill did not start out a prosecutor's bill. We were asked by the representative to come in and look at it and help narrow the bill to the point that we believe it gets to the policy that you're after. Ms. Travis is going to go through some rearranging in just a minute that I think makes it more logical and a little bit easier to follow. But at the end of the day, we believe the bill has been narrowed to the extent that it's not going to be exploited as a defense when it's not appropriate. That was our main concern from the beginning. I want to commend Representative Cooper for being as open-minded and listen to us about the concerns that we had, and letting us get this bill to the point where it covers the exact kind of behavior we're after. I will say this: no prosecutor in the state's got any interest in prosecuting this kid that stays and does the right thing. But I think this is a significant policy statement for this body to make. And then, of course, the educational piece that's got to come with it afterwards is that if you stay and do the right thing, if you take that kid or you call and you ask for assistance, you're not going to get prosecuted for simple possession. And keep in mind, this is not going to protect a drug dealer. It's not going to protect somebody that has got the level of possession with intent. It's very narrow to the lowest level of felony possession of marijuana less than an ounce, and possession of drug-related objects. So when you get into B of 161330, which is possession with intent, distribution, that kind of thing, that's not protected behavior, nor is trafficking or anything of that nature. This is about kids and possession level offenses.
Mr. Pack.
Thank you, Madam Chairwoman. And I apologize for not being here during the hearing. I was quite interested in this bill. From a policy perspective, I know what you're trying to get at, and I have my doubts about whether or not this is actually going to work. Because I think of maybe young kid using drugs at the same time. But first of all, I mean, it's questionable whether or not that person has the judgment, whether because of the influence of narcotics or having decided to actually, in fact, use narcotics. The second is the way it's written right now. There's so many little narrow kind of definitions. When you're having to make the decision at the time whether or not to call for help or not, it's almost like it's very hard to determine whether or not that person fully understands whether they're going to be protected versus not protected. And so I'm thinking I would like to see any statistics from these states that have this statute where this was actually taken advantage of, because I don't, for the person to actually take advantage of and make it the right choice to call for help at that time, that person I think would have to actually know not just there's an immunity, but that they're well within the protection of the immunity. If they don't understand that, they're just going to be, you know what, I'm not going to take my chances and just kind of leave.
Well, Representative Pack, I think you do bring up a point. I think young people that are doing drugs, their judgment is not always good, and that's evidenced by the fact they are willing to abandon people. But as the parents, and when a couple of them testified yesterday, young people afterwards, and the ones that have been prosecuted for leaving, will tell you that they actually discussed whether they should leave or not, or call somebody. So there is a level. The other thing is that, as we said, and as I said to parents yesterday, and I've said to them before, we don't have any mechanism of really getting the law out to young people, but there are young people like the ones here today that I talked about, and the parents of the ones who have lost children that are committed to going around our state, just like mothers did a long time ago when drunk driving was a real problem, and judges were letting drunk drivers off, and they came together and did MAD, and now people know the drug laws. They are committed to doing the same thing with knowledge about this law. And if it's between life and death, I would like to give young people an opportunity to have a chance to do the right thing and for the law to work. And there are statistics, and we try, I believe,
One follow-up.
get them from other states. Some. Mr. Chairman.
133 of the legislative findings, North Carolina for harm reduction coalition actually can show us that 20 lives have been saved in the last year since they passed this law. We are looking at about 18 to 25 deaths per year just from heroin. I think that was the statistic from the GBI, and so it's clearly working. In Massachusetts, in one area in Boston, 120 lives have been saved since 2012 when this bill passed. So it is clearly working.
But in those instances, they say that, but for this law, I wouldn't have called.
Yeah, exactly.
Okay. One follow-up to the procedural question, I think Representative Strickland said, if a DA decides to take this case to the grand jury, is there a law that requires the DA or assistant prosecutor to inform the grand jury of the existence of this immunity?
Well, I think when you analyze that, first of all, it's the district attorney's responsibility as the attorney for the grand jury to inform them of the law that's relevant to a case. I think this is, you can analyze this the same way you can, for instance, the stand your ground law, the whole concept of a bar to being prosecuted if those factors are relevant. I mean, it's the same kind of concept. This is laid out a bar to prosecution if the following elements are present. So, I mean, it's going to be a problem at the grand jury. It would be a problem at trial, and then you could raise it in a plea and bar. I mean, in your first question, I don't disagree with you that this is drawn very narrowly, and the non-lawyer would have a hard time reading that, but you got to understand the other side of this is we also can't create a law that is so broad that it's going to get exploited by a group of individuals that are using, selling, otherwise doing drugs that are not in this situation that you're trying to accomplish. So what I think you're looking for is a policy statement. And the policy statement is in this that is clear is we're not going to prosecute simple possession cases if you call 911 for yourself or for somebody else that you're with using drugs. And this clearly covers that.
Ms. Dickerson? Was that you? Mr. Hightower, did you have something?
Yeah, I think that what you're trying to do is great, and this may be a non-issue. It just kind of popped in my head in this committee when things pop in your head. You really just mention it. Is there any concern there that, because I know what you're trying to do with people, other individuals that are at a scene, they see someone going into a seizure or having these convulsions, you want the people around them to take action. But there's a provision here that says any person who is experiencing an overdose, they themselves can go. Is there any concern at all about that portion of the bill? In other words, someone who figures this out and says, okay, well, I can go get high or do whatever that is, and if I feel as though I'm getting in an awkward situation, I can just call 911 real quick. You see what I'm saying? Now, they're kind of different. The one where they have the individuals around there and they're seeing the person dying and the person can't act for themselves, yes, I agree. We want the people around them to help. But when you have the person themselves there, they made the choice to do it. They're trying to save themselves, but I'm just worried that could it be abused a little bit.
Go ahead.
I mean, what you're after is you're making a policy decision. Do you want me as a prosecutor to prosecute that individual for possession themselves when they overdosed, or do you want them to be able to call 911? I'm not advocating either way.
Yeah.
I think where you're at is you're telling us from a policy standpoint that if you have overdosed yourself and you realize it, and all of this, and we're going to explain that this overdose is not a casual conversation. I mean, it's a significant physical
Right.
that's got manifestations that are going to be crystal clear to the average person. That if you are experiencing that yourself and you're making the decision between laying there and dying or calling 911 about whether or not you're going to get prosecuted for the drug, I mean, you know me, I'm always about the prosecutors capable of exercising discretion in those cases, but I think this is a policy statement that there's a logical tie to, that you've made a decision from a policy standpoint that it's more important to us in the state of Georgia you seek medical assistance than it is you get prosecuted for possession.
And Representative Hightower, I may be wrong, but when somebody gets that ill and is moving toward an overdose or respiratory failure, I would rather see them live than be dead, and we have a chance for them to, get over it. But I think it would be probably very few cases that they would be able to make that.
And I totally agree. The only reason I brought it up is because extreme physical illness, I don't know if that's defined elsewhere, but extreme physical illness, what is extreme physical illness? Is it them throwing up?
No,
I mean, you
that's
see what I'm
not.
saying? I mean,
I think it's got to manifest itself as the intent there.
okay. Okay.
But thank you for the question.
Mr. Grubman. Thank you, Mr. Chairman. When I was in high school, my father said something to me that it really had an impact on me, irrespective of what my behavior was in high school. I remember one evening he said, if you and your friends choose to go out and do whatever, drink whatever, he said, just make me one promise. He said, don't drive. He said, you call me and I'll come get you.
Yeah.
And the impact that had on me was, number one, I had enormous respect for my father, but he was being very vulnerable. But it allowed me to really say, you know what, I can be as open as I want to with my dad now, because I know I'm not going to get in trouble. And I always felt really safe about that, and I never did have to call him. But just him saying that was, I'd rather have you home, and we'll talk about the consequences later, but I want you to call me, and I'll have come get you if you're in a situation like that. But, Mr. Chair, if I may, Representative Pack brought up a good point on the statistics, and I know that Representative Cooper brought some students here, and I'm just flipping through the research that they've done. I wonder if I may be permitted to ask them, did they have some statistics on what the Good Samaritan law in other states, after being passed, what some of the response rate of folks that would call in a situation like that, if I may be permitted to ask, or if they can talk about that?
Yes, sir. We have studies from Ohio University where the Good Samaritan policies were introduced, and the 911 call rate actually increased by 7% over the previous semester before the policies were implemented, and the student body was informed about them. I don't think I've included that in that form. I should have thought of it, but we've in the other states, the other people that we've heard from, we're hearing success stories. I don't necessarily have all the statistics for you guys, but
Well, if I,
we know it's working. I'm
If-
sorry, you can clarify.
well, that's fine. What interested me the most, if I may be permitted, Mr. Chairman, to read one section. It says, the 911 Good Samaritan policies have amazing support from program evaluations. An evaluation out of Washington State found that 355 opiate users were 88% more likely to call 911 during an overdose after their Good Samaritan policy took effect. So,
Is there a problem with that if they called and saved their lives?
no, I was making a point of, I think the bill actually increased. The bill is doing, this is a statement of saying the bill is doing a lot to save lives. It shows me that they're willing to say, hey, we're more likely to do this after the policy is put in place.
Thank you.
Yeah, I mean, it's not an overnight process. We're not going to pass a bill and all of a sudden we're going to see the statistical, bump. It'll take X number of
Yeah.
years of lead time and education. What we talked about very briefly yesterday was, how you message that is going to be, it's a very finessed message because you don't want to go over the top and it almost seems like you're encouraging that type of behavior. But if that behavior, which of course we don't want to do, but if that behavior does occur, know in the back of your mind that making a call is not going to put anyone in a situation. It's just going to save a life. That's threading the needle in the teenage mind for sure. That's no easy task, but I mean,
Thank you, Mr. Chairman.
it's a long-term deal, and the question
Thank
is,
you
what's
for the information.
what's the entity to go ahead and educate that? Is it the schools? And it's the first thing I think of. Where else would it be? There's not going to be a general public service announcement campaign, I don't think. But it'll take time. It'll get itself out there. And over the course of time, that's when you're going to sort of build a statistical case very slowly but surely upward. It'd be 10 years. It wouldn't surprise me at all. Additional questions? Seeing none, what's the pleasure of the committee? Ms. Ballinger moves. Dupat, did you have something else?
Yeah, we're going to have a friendly amendment, I believe.
We'll get to that.
Okay.
We got a move do pass by substitute of HB 965 LC 335546S. Move do pass by Ms. Ballinger, second by Mr. Atwood. Are there any amendments?
Yes, there are members.
Should the chair offer those amendments?
I'm gonna walk through them.
Sure.
Unless we're communicating.
That would scare me as much as it would scare you.
Start with an easy one on line 86. Change here into in this code section. So nothing in this code section shall be construed.
Okay.
The easiest way to walk you through the next one is go to line 47 and circle for which medical assistance is required. Turn to page for which medical assistance is required. Turn to page 3 at line 66 and circle while awaiting the arrival of medical assistance to aid such person. And then on line 67 and 68, strike out for someone who is experiencing a drug overdose.
Sorry, you said strike?
Strike. And after the word medical assistance on line 67, first we're going to insert the circle from line 47. Then we're going to insert the circle from line 66. So that sentence would then read, any person who in good faith seeks medical assistance, which is a defined term above, for which medical assistance is required, comma, while awaiting the arrival of medical assistance to aid such a person, shall not be arrested, charged, or prosecuted for a drug violation, blah, blah, blah.
Could you read that? Just read that, the final product once more.
Any person who in good faith seeks medical assistance, for which medical assistance is required, comma, while awaiting the arrival of medical assistance to aid such person, shall not be arrested, charged, or prosecuted for a drug violation. The way it makes sense is that drug overdose language is contained within the seeks medical assistance, and so that's why we don't need to repeat it again.
Okay. The second clause sounded a little awkward, but
But you've got to require medical assistance and call medical assistance. You've got to use the same term
Okay.
twice in a sentence.
Okay.
There's just no way around it. So it's all the same word, we're just moving them around.
Right. It's lawyer ease, or lease, or whatever. But they get,
The only two such persons to aid medical assistance.
Yes,
We do it.
because it's got to be directly
To that
related to the individual that's overdosing.
All right. The definitions have terms within that we got real circular, so we tried to take them out and use them in context.
okay. Any questions about the proposed amendment from members of the committee? Seeing none, Chair will go ahead and offer that amendment. Is there any discussion on the amendment? Seeing none, all in favor of the amendment signify by saying aye. Opposed? The ayes have it. The amendment is adopted. Are there any further amendments? Seeing none, all those in favor of the lady substitute do pass by substitute of HB 965 LC 335546S say aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mrs. Cooper.
Thank you to the members of the committee and to Mr. Spehouse for helping me so much, and to the young people that brought this to our attention and have worked on it. Thank you.
We will be adjourned. Our next meeting will definitely, barring any unforeseen circumstances, the next meeting will be at our regular time on Monday. On Monday, upon adjournment. Mr. Setzler, we have some questions. So, go ahead.
To the Assessor Subcommittee, we've got a number of bills in there that we're going to take up. I'm actually going to, I know this will be a real crowd pleaser, going to have a subcommittee meeting at 1 p.m. on Friday because we've just got some things we've got to address. And I know you've got full committee on Monday. I want to address that workload.
Full committee on Monday, and that will be an extensive agenda. And it could be very extensive depending on the work of the subcommittees this week. So,
would you be able to take bills that perhaps should pass out on Friday? Would you be able to take them up on Monday?
They will be eligible for addition to the agenda on Monday, subject to review.
Okay. Good.
Fair enough? Okay. Thank you all.